All right, we are live with the Unfiltered podcast with Fabiano and myself, Christian. And today we have a very special discussion. We're going to have a panel discussing the Hans Niemann lawsuit. So this is going to be a very interesting one. Hans Niemann versus chess.com, Magnus Carlsen, Play Magnus. Who am I missing? Daniel Wrench, and I believe that might actually be... Oh, and Hikaru Nakamura, of course. We cannot forget Hikaru. So it's going to be a very enlightening discussion. To be honest, I don't know what to expect. I don't have much experience with law or understanding of law, so it's going to be very enlightening for myself, and I'm sure for everybody else to have a special guest discussing all of this. Fabi, how's it going, man?
It's going well. How are you?
I'm doing well. I'm very excited about this. This is going to be fun. Should be an interesting one. I don't know what to expect, but it should definitely be an interesting one.
It should be interesting. We don't have any experience in law, but we do have an excellent commercial litigator who will be joining us.
Yes.
An expert in these things for sure, so he'll know everything that one could know without being inside the case.
He's going to explain everything.
And he'll share his expertise with us. But yeah, it's an interesting one. It's a 42-page lawsuit against multiple people, as you mentioned, against Magnus, against the Play Magnus group, against chess.com, against Danny Wrench, in quotation marks, and against Hikaru. I guess we could have expected that it might happen, this lawsuit, at some point. It wasn't a huge surprise, right?
No, I think I think that was definitely the natural conclusion of all the drama that's been going on for the past month. It just felt like at some point this should be the climax, right? Just have a lawsuit. Otherwise, yeah, to be honest, it felt like it was a forced move for Hans. Let's just put it that way.
Well, this is hard to say because it could turn out well for him. It could backfire. I mean, you know, these we're not going to get an answer anytime soon. These things will they tend to drag out quite a bit. But for a young guy, of course, it's also, as Hans is, I think he's 19 years old. It's a distraction from his main career as well. So it's not like you just throw a lawsuit out there and go on with your day.
Yes,
it's a big one. I mean, the lawsuit itself is for like nearly $500 million.
So my understanding is that it cannot be more than $100 million. I don't think it adds up to all the parties. So I think maximum he can get is $100 million. At least that was my understanding. And again, we will be discussing that.
Okay, yeah, we'll ask Akiva Cohen that.
Yes.
When he gets on. But in any case, I guess it's the biggest lawsuit that's ever been seen in chess, right? I mean, I can't think of anything of this size. I remember in the past there was a lawsuit over chess engines.
Yes.
Over, if they were using code from other chess engines. I think this was involving Ripka, so this was back in the day when Ripka was a thing. And but that wasn't anywhere close to this. And also there was another lawsuit involving when there was a chess company that attempted to copyright moves played in their tournaments. I think this was World Chess. At the time they were called Aegon. And they were trying to have the intellectual property rights to moves played in tournaments that they organized. And I don't think that worked out for them. So yeah, there's been a few lawsuits, but never one of this size in terms of the money and the amount of people involved.
No, absolutely. The magnitude is overwhelming. It's going to be overwhelming for the next few months until we get a conclusion. Maybe it's going to drag on even more than that. So It's going to be an interesting time in the world of chess. And to be honest, let's, by the way, somebody saying that we're not live is pre-recorded. No, we are live. This is not pre-recorded. So there will be maybe some technical difficulties along the way. By the way, how is the audio? How is everything else looking like? If you guys give us some feedback, that would be great. And yeah, I think Akiva is actually just about to join us. And we should get him soon as fast as possible and then start discussing, because we have a lot of things to discuss. So let's get him on. Fabi, anything to add before we get Akiva on?
No, let's get him on. We have a lot to discuss, a lot of questions for him, and it'll be interesting to hear what he says.
And by the way, were you guys worried about being sued also? Somebody is asking. I don't
No.
I don't think we were.
No, we were. I mean, I don't think you were, Christian. I definitely wasn't.
Yeah, no, I wasn't.
I mean, we didn't at any point say that we thought he was cheating or not cheating. And again, there was a lot of people who talked about these matters, but I don't think there's anything against the law in terms of talking about things and not incriminating someone or libeling them, which, or in this case, slandering them, which we never did. So yeah, I don't think we had any reason to be worried.
All right, we're going to get Akiva in right now. So stay with us for a second, guys. Hello, Akiva. Can you hear us?
Hey, how's it going?
Hi, Akiva.
Very well, very well. Thank you for joining us. Say hi to the YouTube chat. So this is going to be a live show. Once again, we are not experts in law, so that's why we wanted to have you on. Thank you very much for accepting to be on the podcast.
I appreciate that. I am very much not an expert in chess. I will say I did some Googling. I did see the horsey moves in an L shape, correct?
So, that is correct.
Okay, good. So, I mean, I have some of the basics down, but yeah.
And that's another thing. If you have any questions about chess, feel free to ask us. If you have any questions related to the lawsuit that maybe you did not understand because you are not in the chess world, feel free to ask us as well. We will try to cover as much ground as possible. So yeah, let's start it off with your thread, with your Twitter thread. I think that was very well documented. What would you say the most striking factor in this lawsuit is?
So, look, so I'm going to talk about this as a lawyer, right? And as a lawyer, the thing that jumps out to me quickly is actually the procedural question, which is, why in the world was this lawsuit filed in Missouri, right? The initial game was played in Missouri, but there's a pretty basic rule in law, which is you can't just sue anybody you want to anywhere and force them to show up and defend themselves. You have to have some basis to say that that person is subject to the power of a specific court. Fabiano, if I were to sue you, I don't know where you're based, but if I were to
also Missouri.
Oh, you're in Missouri. Okay. So if I were to sue you in, Iowa, right? Like, there would have to be some reason to say that a court in Iowa has any power over you at all. Can't just grab you and yank you somewhere that you've never been, where you never did anything wrong. And Niemann is based in Connecticut. He's got defendants who are based in Utah and Norway and Florida. Nobody's based in Missouri. So to get jurisdiction over them in Missouri, you basically have to say that each and every one of them individually did something that either harmed Niemann in Missouri or it was some wrongful act that happened in Missouri. And the only person in the entire complaint who does anything in Missouri is, of course, Magnus Carlsen. When he's playing the game and he makes whatever comments that he makes at Sinkfield, he's in Missouri. But Nakamura, he's he's got no connection to Missouri, and he's not alleged to have done anything in Missouri. Chess.com is not based in Missouri. They're not alleged to have done anything in Missouri. Even Play Magnus as a company isn't based in Missouri, and it is not as a company alleged to have done anything in Missouri. So one of the very first questions before you start worrying about whether or not the case is well pled, whether it states a claim, whether, you know, who's going to win, who's going to lose, if I were representing any of these defendants, the very first thing I would do is I would say, I don't belong here. You can't sue me here. If you want to sue me, you better sue me someplace where the court has power over me, and try to get out of the case that way. Now, a lot of times when that happens, a plaintiff will say, okay, well, I'm going to sue you in some other jurisdiction. This case, because it is a defamation case, is different, right? So a lot of states, when dealing with defamation cases, have passed what are known as anti-SLAPP laws. And SLAPP is an acronym for Strategic Lawsuit Against Public Participation, SLAPP. And the reason for that is a lot of times what was happening was people would say things that were critical of large companies or famous people or wealthy people who could afford to go out and hire a lawyer to sue over it, whether or not that lawsuit had any particular merit, because they knew that just the threat of a lawsuit would make the person criticizing them shut up. Lawsuits are incredibly expensive. They're not just incredibly expensive, they're incredibly time-consuming. The process often is the punishment. And so people were using the threat of defamation lawsuits as a way to avoid legitimate criticism. So a lot of states have passed anti-SLAPP laws that say, look, if you're going to file a defamation lawsuit when somebody is talking about an issue that is of public concern, you know, anything that is essentially in public, or about somebody's exercise of their First Amendment right to free association, who they hang out with, you have to come right up at the front and show me that you have evidence for every single thing that you're alleging. You can't just say it in the complaint and say, I'm pretty sure I will find the evidence when you let me do discovery. I really believe this is true. You have to, right at that opening stage, have evidence ready to come to court with. That's a high standard. And if you lose that motion in states that passed anti-SLAPP statutes, you actually have to pay their attorney's fees, which is a great thing in terms of what it lets people do in terms of criticizing other people, because now it's harder to scare me off of criticizing you, because I know that if it's a frivolous lawsuit, if you don't have evidence that I was actually doing something actionable, I'm not going to be the one who has to pay for it. You large company, you celebrity, you deep-pocketed guy, you're going to have to pay for it. So I can keep criticizing you all I want. Missouri does not have a good anti-SLAPP statute. Connecticut, which is the other place where Niemann could file this, has a terrific anti-SLAPP statute. And so
is that the reason why you think that he would have filed in Missouri rather than Connecticut, because he's trying to avoid that statute?
Oh, definitely. There's almost no question. It's not where his lawyer is based. His law firm, Ovid and Ovid, they're based in New York. So it's not convenient for the lawyers. It's not where he's based. So he's not picking a forum that's convenient for him. And it's not where the defendants are. So it's not like, yeah, I don't want to travel to Missouri to do this, but this is where I can sue everybody. The only connection is for Carlson. And so it's pretty clear it was picked for a different reason. And the only reason I can think of is because he wants to avoid that anti-SLAPP statute. And what that means, circling back to what I was talking about the first time, is that if Nakamura and chess.com and Play...
I think we lost Akiva for just a second there. Perhaps we will be able to get him back.
Sorry.
We got you back.
Did I freeze? Sorry.
Yeah, you cut out for a sec. So we
Sorry,
got you
so
back
I
now.
was saying, if those other defendants are let out and Carlson stays in, Niemann might actually decide, you know what, for my purposes and really what he wants,
I think we.
and get some back from Magnus Carlson. For my purposes, you know what, I will just leave Magnus Carlson as the only defendant, and I will just take discovery from all these people and make them give me documents and testimony, but I don't have to go sue them in Connecticut or Florida or Utah or somewhere else and have either multiple lawsuits going or one lawsuit in a state where it's going to be even harder.
And Akiva, one question. Can this lawsuit be dismissed based on wrong jurisdiction? You mentioned that perhaps only Magnus might be in the right jurisdiction at that moment.
Yes.
Could this case be dismissed since a lot of other parties that are being, well, on the other side of the V, a lot of the parties are not based on that jurisdiction?
The case that gets dismissed, it's the defendants.
Mm-hmm.
So if I sue 7 people in New York and only one of them is subject to jurisdiction in New York, I can keep going with my suit against that one person. And those other 6 people can either say, you know what, fine, I'm going to litigate with you in New York and consent to the jurisdiction, just come in, file an answer, and move on, in which case it all continues. Or they can come to court and say, court, and the court will dismiss those defendants, but not the one that I have jurisdiction over. So if that's what's going to happen in this case, it's going to be that the lawsuit will continue in Missouri against Carlson, but not against everybody else. Perhaps there's an argument for Play Magnus. It would have to be based on the argument that when Carlson was talking and doing the allegedly wrongful things in Missouri, he was acting on behalf of his company as well.
I actually had a question about that because Magnus is a very small shareholder of the Play Magnus Group. He owns, I think it was only around 8% of the company. Mm-hmm. And the actual company didn't make a public statement accusing Niemann of anything. So I was wondering why they would be included in the lawsuit if they haven't slandered him, libeled him, and if Magnus is only one shareholder out of many.
Right. So I will be honest, I did not look at the officers of Play Magnus Group before when I was doing the thread. And you just brought this up and I just ran a quick Google search. So the way it works is corporations can be held liable for the actions of their employees, for the actions of their officers when they're acting on behalf. Assume that Magnus Carlson was, the CEO or the CFO, or was somewhere as an officer of the corporation. Running over to their website, he's not listed as part of their management team. He's not on their board of directors. Just clicking on the link that says Magnus Carlson and then roles in the company. Here's what. Actually share my screen for, oh no, screen sharing is disabled. But if you go to their website, it says, roles in the company. He's a key shareholder. He's a content creator. He's a special advisor, and he's a key part of the Champions Tour. They're going to have a very good argument that he is not the type of employee who can bind the company or who can act on behalf of the company, and should create any sort of claim against the company because, as you said, he's an 8% shareholder. And if he was an 8% shareholder and the CEO, or an 8% shareholder and, he was playing in the tournament on behalf of Play Magnus Company, that would be one thing. But he's not. He's an 8% shareholder and he's a special advisor, and he was there in his personal to tag the company with his conduct. So that would be another basis on which Play Magnus, if it wanted to, could seek to get out of the case. And again, just knowing what I know right now, it's probably pretty likely that they'd win that motion if they made it.
Could there be a problem that Magnus is not an American citizen? No.
No. So there's actually a treaty, the Hague Convention on the International Service of Process, by which pretty much most of the countries in the world have agreed that if one of their citizens is getting sued in another country, you can serve them process, which means that they are legally required to show up and defend. Whether that means show up and say, hey, there's no jurisdiction over me because I didn't do anything here. Magnus actually did something while he was in Missouri that is being alleged was wrongful. And when you do that, you can get sued in Missouri. It's fair, right? Like, just think about it. If this wasn't a defamation case, let's say he was out driving one night and he crashed into somebody and he injured somebody, right? And then he flew back to Norway. That person in Missouri could sue him because while you were here, and everybody agrees it would be fair for him to have to come back to Missouri to defend against the case because he did the bad thing in Missouri. And it's the same thing here. If there's a basis for jurisdiction over you, as long as you are correctly served with process, which means you get a certified, in this case, copy and translated copy of the complaint served through or whatever central repository there is in Norway to officially accept process on behalf of lawsuits from other countries, and that gets served on you. You have been served and you have to show up.
Got it. Now, one of the things that you mentioned in your thread is that you believe having Hikaru as a defendant is actually a blunder from Hans's side. Could you elaborate on that a little bit?
Sure. Any case, credibility with the court is always a very big deal, right? And credibility with a jury is always a very big deal. And so you never want to put yourself in a situation where you are saying something that is very hard to believe or that is going to be easy to disprove. And so making the allegation conspiracy where all he is a commentator who comments on chess.com, and obviously that's not all Hikaru Nakamura is, but for purposes of this situation, that's his only connection, right? They didn't have to argue that he was a co-conspirator who was in a plot with these guys. You know, it was a secret agreement to destroy Hans Niemann. They could have just pled the case against Magnus Carlsen. They could have even pled the case against chess.com and said, we'll take discovery, which means, you know, once the case is up and running, you get to say to the other side, give me all of your relevant documents, show me your communications. And then if there's some fact in there that shows that he was actually a part of this, you can say, wait, another defendant, and here are the facts on which this is based. So it wasn't like it was use it now or never do it. Instead, they crawled out onto a limb and said, this is a conspiracy involving Hikaru Nakamura. And if they're wrong about that, right, and I'd say entirely probable that they're wrong about it, he also said bad stuff about me, so it must be a plot that he's a part of. That will make it easier for a jury to think that they're wrong about everything, right? If I'm representing Magnus Carlsen, you know, and I am able to have a jury look at this and say, well, they accused Hikaru Nakamura of being in a conspiracy. They were just making that up. There was no evidence. Look, Hans Niemann is a conspiracy theorist. He thinks everybody's out to get him. He invented a conspiracy about Hikaru Nakamura being, wanting to defame him. And he is inventing a conspiracy that Magnus Carlsen didn't really believe that he cheated and was making it up to try and, help his share price in his sale of Play Magnus. And the same way he was wrong about Nakamura, he's wrong about Magnus Carlsen. And as a plaintiff's lawyer, if I'm representing a plaintiff, and I do work on both sides of the V, you never want to give your opponent that sort of easy, come on, he's wrong about this, so he's also wrong about this. It hurts. There's no reason to do it. They could have made that claim later if the evidence supported it.
So this whole thing about it being a conspiracy, I see this language, and I'm reading through the lawsuit right now. I see this language often, which it's trying to draw a parallel between chess.com, Play Magnus Group, Magnus, Danny Wrench, and that they conspired to damage his career for whatever reason. And it's even quite early on that, let me just read through this.
Yeah, I mean, that's their theory of the case.
But how easy is it to prove a conspiracy? Isn't it very, very difficult?
Yeah, it's going to be very, very difficult. And frankly, I'm not sure they've even alleged enough of a motion to dismiss. I mean, when you're pleading a federal complaint, you've got to allege facts that would let a jury say, okay, if these facts are true, then there was an agreement. All they've sort of alleged, there was an agreement to do the bad thing. All they've sort of alleged is Magnus had an economic interest for this. Magnus did it, and chess.com did it. Therefore, they must have agreed. And that is really, really close to essentially the paradigmatic case that the Supreme Court said, yeah, no, that's not enough. The Twombly case, which was Bell Atlantic v. Twombly, where essentially the allegation was a bunch of companies were conspiring to fix prices, and the allegation they all set their prices the same way. Obviously, there must be an agreement. And what the Supreme Court said was that's not good enough, because it could just be that they all, responding to the same market pressures, set their prices that way. It could just be that they all, looking to compete with each other, set their prices so that, nobody was too far from the other ones independently. And you didn't acts that would make it plausible that there was an agreement to do this between them. And that is missing here. I don't see anything in the complaint that shows an agreement between Magnus and chess.com to, push this cheating narrative. You just know that Magnus is doing it and chess.com is there as well. Come on, they must have. And in federal court, that's not good enough.
So the fact that there was a merger happening at the exact same time as the Singfield Cup, the tournament where all of this transpired, that wouldn't be enough to prove a conspiracy, or to at least convince a jury that there might be some sort of collusion between chess.com and Magnus.
Right. Look, where it's so wildly crazy that it would be insane for a judge to look at this and go the other way. But if I were the judge on that case, what I would say is no. The fact that there is a business agreement between these two folks doesn't mean, all that means is that chess.com has a motive, if they believe has a real claim, to say so. That doesn't mean that Magnus Carlsen and chess.com sat in a room and said, hey, this guy beat me. We better lie about him so that we can save my reputation. It's not enough, in my view, to get you there. And so, again, like with Nakamura, this is one of those situations. Me pleading this, what I would have advised would be, let's just go in with Magnus. And we have all of these other folks sort of on the periphery. Let's take discovery and let's see if we can get facts that will support the claims that we want to bring against them. And if so, let's bring claims against them. But we don't have to do it right now on the evidence that dismiss. And if I had to handicap it, we would probably lose that motion to dismiss. So, you know, I mean, again, I'm not a big chess guy. You know, I play badly. But, you know, I don't know moves. I don't know, you know, famous openings. But litigation is war in the same way that chess is war. You can't, because they look pretty. You have to have a strategy, and you have to think about, how is my opponent going to respond to this, and what am I going to do when he does respond to it, and how is it going to benefit me? And this has the smell of a pleading that was, you know, designed to be showy and get attention, which I understand. I mean, Niemann has PR goals here. I'm not sure they have well planned out responses for some of the obvious next moves of most of these defendants, and where they didn't have to make this type of aggressive move to accomplish what they wanted to accomplish. I'm sure, by the way, that if you interviewed Darren Oved and his team over there, they would say the exact opposite. They would say, no, we have a strategy, but I can't think.
So one of the key points of this lawsuit is there's an accusation of a group boycott. And early on, they suggest or allege that chess.com agreed to acquire, this is from the contract, Play Magnus for nearly $83 million and merge the two companies in order to monopolize the chess world. So it seems to suggest that there is this plan that these two companies are merging. They're trying to force everything else out besides chess.com. And they're also trying to boycott Niemann from playing chess on their site. And I think they'll argue that he was banned, which is pretty much public knowledge at this point, that he was banned from playing after the Magnus Carlsen incident. Is there any sort of argument there that what was the timing of this ban? Why was he banned at that moment? Did Magnus maybe suggest like he shouldn't be playing, and that is why they're saying this is a group boycott? And they also use this, I think it's an antitrust law, the Sherman Act. They mentioned that as well.
Right. So the Sherman Act is what covers group boycotts. So yeah.
So is there some sort of argument that they're making there? Does that hold water?
So, and a antitrust lawyer, and antitrust law is its own subspecialty. So asking me to comment on antitrust arguments is, you know, very much like, you know, look, all doctors are doctors, but you're not going to go to a cardiologist to deal with your, you know, cancer. It's just, those are two different fields. So don't take this point, you know, when you're talking about antitrust law, I am at best an educated layman. I've seen it in my career. I've touched on it sometimes, but it's not something that I know real solidly. But my gut is that a group boycott claim based on Magnus Carlsen saying, I don't want to play against cheaters, saying, we don't want to allow a cheater to play on our site, and we know he's a cheater, is going to be really, really hard. That's not so much a boycott where you're saying, I don't want, especially when it's one person, right? Like it's not a class of people and it's not a competitor of chess.com that they're freezing out. But again, not my area. I don't get too much into the weeds on what's going to happen with the antitrust claim, because I don't want to get out over my skis beyond where I can go.
So it seems to be that Magnus definitely had not necessarily intent, but he believed that Hans cheated during Sinkfield Cup, at least according to his statements. What Hans needs to actually prove is that this was all a conspiracy, and actually that Magnus did not believe that he was cheating, but only wanted to hurt him. Is that correct?
Correct. Well, almost. So whether or not Magnus wanted to hurt Hans isn't really an element, right? So for example, if Magnus didn't believe that Niemann was cheating, but he thought, oh man, protect my own reputation, and he doesn't care what that does to Hans. So it's not I want to hurt him, it's I want to protect myself. That still would be defamation if it's false and deliberately false. What you're talking about is probably one of the worst named rules in American law, which is something that the Supreme Court decided to call actual malice. Speech is ill will. So everybody hears actual malice as the standard for defamation when the plaintiff is a public figure, and they think, oh, I know what that means. It means that the person who defamed me did it because they wanted to hurt me. That's not what actual malice means in this circumstance. For whatever reason, and if I could go back in time and strangle somebody, malice towards the truth, ill will towards the truth, meaning that when you're defaming a public figure, somebody who's well known, whether in the general population or a particular industry, the way Niemann is well known in chess circles, as I understand it, what you have to show is that the person doing the defaming, the person making the false statement, said it either it was false. So at the time that he said it, he knew Niemann had not cheated, or said it while subjectively, internally thinking to himself, you know, I'm not really sure this is true. I've got some real doubt about whether this is true, but I'm gonna say it anyway because I want to, right? Those are the two. So it's either deliberately false, which is called reckless disregard for the truth. That's what actual malice means. So it doesn't matter whether he wanted to hurt him or help him or, you know, clean up chess or protect his own reputation. What Hans Niemann is going to have to show is that Magnus Carlsen, when he accused Niemann of cheating, either knew for a fact that Niemann hadn't cheated or really didn't believe it wasn't.
And now there is also the thing that Hans admitted to cheating actually in one of his interviews, and I think this is a big piece of the puzzle. He admitted in certain interviews about cheating online.
Right.
Could that information, Hans admitted to cheating, can that be used to pretty much throw the case away as evidence?
Admission, if I'm understanding the timeline correctly, that admission came after Magnus at least first implied that
Correct.
Hans was cheating over the board.
Correct.
Right?
Yes.
So it's not like Magnus is going to be able to say, well, I knew that he had admitted to cheating online. I knew he had been cheating online because he admitted it. And that's part of what made me believe it. And so it was he was cheating and there's no evidence that so that's not going to come into play that way. The way it's going to come into play is down the road Number one, there are going to be questions about what his damages really are, right? Because maybe some of the damage isn't so much because Magnus Carlsen accused you of cheating at Sinkfield. Maybe a lot of the damage is because you admitted to went and looked into it, and said, "Oh wow, you actually cheated way more than you even admitted to. You tried to minimize it, and that destroyed your reputation."
Will this information be forbidden for the defense to bring up in court?
Oh no. There, if it ever comes to the point where they're going to be, talking, that's gonna be front and center, and they're not going to be able to get it kicked out of the case because it's relevant.
Yeah, that makes sense.
Is it likely that since this whole thing took place at the St. Louis Chess Club, that a representative of the St. Louis Chess Club will be asked to give testimony, either for Niemann's side or for the other defendant's side?
Oh, it's inevitable. Lawsuits work in America is a plaintiff files a complaint, and then defendants, if they don't move to dismiss, which is basically saying to the judge, "Look, judge, what they've put in their complaint, even if all of it is true, wouldn't give them a basis to sue me. So why are we doing all of this? Just get rid of it." So you can move to dismiss. But if they don't move to dismiss, you file an answer, which basically, allegation number 2, I deny. Fact number 3, I don't know one way or the other, so I deny it. And you go through the complaint and you basically set up, okay, these are the disputed facts. And then you get into discovery. And in the discovery portion of the day, you get to serve document requests on your opponent. So give me all your documents. You get to serve interrogatories. You can ask them to answer written, which means you can ask them to show up in front of a court reporter and answer questions for 8 hours of on-the-record time, which is, frankly, a blast as an attorney and not at all fun as a witness, and I have been both. And you can do the same thing with a subpoena for third parties. And so there will 100% be asking for all of their information about what they do to protect against cheating and what was going on in the Niemann-Carlsen match and whether or not they thought there was cheating. And they are going to take depositions, and probably Niemann is going to want that testimony more than Carlsen is, given what I understand the Sinkfield folks were saying about whether or not there was cheating there. Mm-hmm. He's going to want to take depositions in a way that will be usable at trial, whether on a transcript or you can even use a recording. You videotape depositions a lot, saying, no, we had no evidence that there was any cheating in this game. And these are the things we do to detect cheating. And no, none of it was happening as far as we can tell. That will be very useful evidence for Niemann. And he's absolutely.
Now, before actually this game happened at the Sinkfield Cup, there was a match between Magnus and Hans, which was played in Miami. Now, in preparation for that match, they also played a lot of games on the beach for promotional purposes. Now, the rumors, and these are just rumors, obviously, are that Magnus really beat Hans quite badly in that, and that fueled his suspicion as well.
Hold on 1 second, guys.
Yes.
Hey, little one, can you tell your mama I'm on a conference, and I will get you the cookie cutters after it's done, okay? Wave to people. You're going to wave to people? Oh, good. Okay, just so you know, she's going to keep waving until somebody waves back.
That's...
So, Fabiano, since you're the only one on video, that's you. All right, good job.
Oh yeah, I forgot that I'm not on video on Zoom.
Yeah.
So yes, those to get back to the question, could that be used as evidence to support Magnus's claims that he truly believed that Hans has cheated?
Yeah, of course. I mean, anything. So where the rubber is going to meet the road in this case is going to be, Magnus saying and Hans saying, no, you didn't. And so anything that Magnus can point to say, and I believed it because of this, and I believed it because of this, and I believed it because of this, he's going to be saying that to a jury that is listening to that, and anything that makes sense to them and makes him seem more credible will help him. Anything that makes him seem less credible will hurt him. And that's, assuming it gets to that stage. Again, the concern, if I'm Niemann's lawyer, is did I do enough to allege at this pleading stage facts that would let a jury say that he didn't really believe it? And I think one of the ways that they almost shot themselves in the foot a little bit, there was a lot of language in the pleading about how Magnus snapped and he couldn't believe that he had lost, and his ego wouldn't let him believe that he had lost legitimately. Well, all of that is saying that, yeah, he psychologically really believed that Niemann cheated. It must have been. That's the only way he could have beaten me like this. Well, if you're going to plead that, you just pled that he didn't have actual malice and the case should go away. So that's a problem for Niemann. But assuming it gets down the road that point, then yeah, Magnus is going to have to convince a fact finder. And when I say he's going to have to convince, the burden of proof here is always on Niemann, right? So that means Niemann has to show that it's 50.1% likely that Magnus didn't actually believe it. Tie goes to Magnus. But when a jury is assessing those types of things, it's listening to people and it's saying, does this make sense? And what's the external evidence that they're bringing in that supports their one story versus another? And so, yeah, I mean, Magnus is going to have to be credible when he says, I really believed it. And these are the reasons why I believed it. If he just walks in there and says, yeah, I believed it, and I believed it because I just did, a jury is going to look at that and go, no, you didn't. You're making that up. You can't even come up with a reason why you believed it.
If I'm Magnus and I say, so the point was that his admittance of past cheating isn't admissible because it happened after the fact.
Well, it's not that it's not admissible. It's just, it's not going to be a basis that Magnus can say on the day of the Sinkfield tournament, that's one of the reasons why I thought he was cheating, because it hadn't happened yet.
And if Magnus says, well, I knew about it from chess.com telling me about the cheaters that had cheated on their website, could that lead him to trouble because of this kind of conspiracy charge?
No. I mean, that would be, number one, he'd have to have evidence of that, right? Like, he'd have to have somebody else from chess.com saying, yeah, before his match, we were like, hey, by the way, you should know, look at all of this, assuming that happened, right? But assuming he were to say, yeah, I got information from the following sources that told me that this guy cheats a lot, he's going to have corroborating evidence backing up that, yeah, he was actually told that. But yeah, I mean, just think about it, right? Like, if you're a juror and you're being asked, hey, did this guy really believe it? Would the fact that other people had told him in advance, hey, just be aware, this guy is a cheater, would that make it more likely that he really believed it? Yeah, it would. And so that's going to be relevant and admissible, right? Evidence is relevant. The definition of relevance is basically, does this fact make the thing you're trying to prove either more or less likely? Mm-hmm. If it does, then it's relevant. And if it doesn't, then it doesn't, right? Like, what color shirt the guy was wearing, not relevant. Doesn't make cheating more or less likely. The fact that he was told this guy's a cheater, if that's what he was told in advance, yeah, that would make it more likely that he would believe that the outcome here was cheating. So it'd be relevant.
Just as a hypothetical, imagine that during the tournament after losing to Niemann, he tells the St. Louis Chess Club, either you kick this guy out of the tournament or I'm leaving. Would saying something like that behind closed doors, would that get him into trouble if that was proven?
It's the same. So either you kick him out or I'm leaving. He's allowed to say that.
Okay.
Right. Like, you don't have to stay somewhere. There's no contract forcing you to stay somewhere. Mm-hmm. Again, I don't know the chess world, so maybe there are contracts, in which case
there are contracts in there.
Yeah. So, if there are contracts, then there's a whole different analysis based on those contracts, right? But if he's saying, look, I believe this guy's a cheater, I'm not staying to play with a cheater. If he's in the tournament, I'm out. You're allowed to say that, assuming you believe it. If you don't, then you're lying to somebody, making a false factual claim about them and harming their reputation. It's defamation. Mm-hmm.
So this really comes, in terms of Magnus, this really comes down to his state of mind. So it's going to be either he has to prove his state of mind, or they have to prove that he was acting
the other way around. They have to prove that his state of mind is not what he says it was.
Mm-hmm. Okay.
And that's, it's funny. This comes up a lot in public figure defamation cases when the person who's claiming defamation has fans, right? Because they're like, wait, that's not fair. He has to prove a negative? How's he going to prove a negative? That's impossible. Yeah, that's why public figures don't bring defamation claims. The standard of proof is so high. It is, without question, as far as I can tell, the hardest case to win as a plaintiff in the country. It's just, the standard is so high because the excuse, you can prove that what the guy said about you was 100% totally false. And by the way, not just false, but crazy. And if the jury believes that the guy who said it was either really stupid or really crazy and actually believed it, you lose. It's a really tough burden to carry.
So knowing the difficulty in these types of cases, why would a big law firm like Ovid and Ovid take this case? What's in it for them? Is it publicity? Right. Is it just money, or why are they doing this?
So, I mean, first of all, Ovid and Ovid, it's not a big firm. It's when we talk about big firms, we're talking about firms like Cravath or Skadden. Firms like big law firms have 1,000 lawyers. They're behemoths. That's not to say that a small firm like Ovid and Ovid doesn't do exceptionally good work. I know plenty of small firms that do work exceptionally well, that can kick the ass of a big firm, kick the butt of a big firm, no matter what, one way or the other. I do that sometimes. But point being, right, big firm, small firm isn't really the question. Why would they take this case? Look, this case is it's not a crazy case. I think there are some aspects of it that haven't necessarily been handled the way I would have handled it. And there are some aspects to it that I think could be done differently. But the claim that Magnus was lying, and he was deliberately lying because he was concerned about what this bad of a loss would do to his brand, it's at least it can pass the smell test as something that could be true. And so if you have a client who comes to you, number one, there's a level of challenge, but number two, I think the thing to remember is Niemann, if he loses this case, but loses it because yes, the accusation was false, but you can't prove that Magnus didn't believe it was true, he still wins, right? He doesn't win money. He's not going to get a judgment. But the outcome is going to be, the headlines are going to be Niemann vindicated, Magnus wrong, Magnus was dumb, he had a bad opinion, and so he's not liable. but he was wrong. He falsely accused this kid of cheating and caused him real problems. And he's not liable in a court of law, but in the court of public opinion, people are going to hate him, right? Like that's the outcome for Niemann if he loses, but loses on there was no cheating, but he still gets out of it without a liability. So from the client's perspective, there are multiple avenues to, quote, win. From the lawyer's perspective, it's not a frivolous case. There's a real basis to it. I would assume Niemann is paying. This is not the type of case that I would take on contingency. It is way too risky as the lawyer to do a case like this on contingency because the chances of recovery are frankly really low in my opinion. But you know, maybe they have whatever mix of cases that they have that they're like, you know what, we can take a swing on something like this because we have enough paying work that this is pure gravy if it hits, and if it hits big, it hits really big. So, you know, it comes down to risk tolerance for the lawyer. But this is not the type of case where it's like, why would you take this case? You know, there are cases, right? So like the Sidney Powell election lawsuit cases where like, no, this is crazy. The things you're saying make no sense. It's frivolous. You're going to get sanctioned. And that's what happens. The Vic Mignogna defamation case where the defamation claim was, yes, I engaged in the conduct that these people said, but it was all consensual. You're accusing me of sexual harassment, but really you agreed to fool around with me. It wasn't pressure, you know, it was all okay. If the defamation claim as a public figure is that your subjective experience of our behavior is wrong, you're going to lose. It's dead from the day one. So those are cases that make no sense for a lawyer.
Is there any scenario in which Hans gets countersuited? Is that an option? No.
No. I mean, listen, you know, is there something that he could do or say between now and, you know, the end of the litigation that would trigger a countersuit? Of course, people can do or say stupid things. Is there anything in the fact pattern thus far that would trigger a viable countersuit? Not that I can see, no.
Got it.
What are the chances that this gets settled just because the defendants don't want to deal with it? It's a big, messy procedure, and they'd rather just pay to make it go away.
I'd say pretty low right now. So the same PR problem that Hans has, Magnus has if he settles, right?
Mm-hmm.
If he settles this, the narrative is immediately going to be, see, he was in the wrong and he knew it. So that's a pretty strong disincentive to settle. And then he's in a strong position to start because of how high the burden is. Now, if this gets past a motion to dismiss and into discovery, now the chances of settlement go up. After discovery, there will be motions for summary judgment, which is basically where the parties go to the judge and say, look, judge, based on the facts that are no longer in dispute, everybody agrees this happened, that happened, and this third thing happened, I win. So we don't need to have a trial with a jury to figure out which one of us is right about the things we're fighting about because they don't change the outcome. If it gets past that stage and starts heading to a trial, now all of a sudden the pressure on Magnus to settle ratchets way up. Mm-hmm. Because now you're looking at a range of outcomes that go between, you know, a total loss, a loss on it wasn't cheating, but you really believed it was. So it's just you were wrong and therefore you're not liable, and a victory. And trial is really expensive. So at that point, maybe the incentive shifts enough to get to a settle. But I would not expect this to settle until after at least some discovery, and probably not unless and until it survives summary judgment.
Okay. So I was reading through the language of the lawsuit and I was a bit surprised. I mean, I don't have any experience with this, but some of the wording just seemed rather unusual to me. Like from the very beginning, Magnus is described as Mag Carlsen, having solidified his position as the king of chess, believes that when it comes to chess, he can do whatever he wants to get away with it, which is just an opinion which someone can have. But why would language like this be included in the lawsuit?
Well, let me ask you a question. What was Hans Niemann's goal with this lawsuit?
That's a good question. With like a little bit of knowledge about his motives, I don't think that he himself intends to get a settlement. I think he wants to see this one through.
So that's number one. And number two, he needs to change the narrative, right, that's out there in the media right now and that's out there in the world about what's going on with him. And so if he just filed a sort of bland defamation suit, you know, it would have been a 2-minute story. Niemann sues for defamation and then probably would have fallen off the news cycle. His goal here was in part to get attention. And I think also he's really angry. And so he wanted, I mean, he's 19. And from what I can see from the little that I've seen, he is somewhat prone to anger. And I think he wanted to get some back, right? Like he wanted to publicly humiliate Magnus Carlsen. He wanted to hurt him, or at least make him regret being in this fight. And so he probably asked the lawyers to write this in the sort of inflammatory, over-the-top style that he got. I think that's what he wanted, both for PR goals and for personal goals. Does it make the lawsuit more likely to succeed? No. Does it make the lawsuit more likely to fail? For the most part, also no. And there are some stuff like we talked about with the actual malice and the Carlsen snapped, where I think it does cross the line and hurt the lawsuit a bit. Same thing with naming Hikaru Nakamura. It seems to me that is mostly on, Hans Niemann being upset that Nakamura was talking about him in the way that he has been and wanting to, fire back and insisting that the lawyers include him. Strategically, I think that was probably a poor move. But, other than those couple of things, does the language help or hurt the likely outcome? Not really. So.
Hypothetically speaking, if Hans manages to prove that Magnus, before he quit the tournament, spoke, let's say, and colluded with the people at chess.com, or he was shown, let's say, certain graphics that the people at chess.com had, would that help his case?
Well, it depends what you're talking about, right? So sharing information, it's not illegal, it's not tortious. Mm-hmm. There's no problem with it. What he needs to show is not just sharing information. What he needs to show is that chess.com and Magnus shared a concern for how this game would impact their business. If he can show that, then all of a sudden the sharing of information gets contextualized as that's their response to this concern. And you can see there was a conspiracy. You can see they were working together to address this concern. But unless he shows evidence of that shared concern, then just the fact that somebody's sharing information with a business partner doesn't help him all that much.
Well, so Hans was banned from a tournament that he had qualified for, not that he was just invited for, on the chess.com website. And this happened roughly immediately after Magnus withdrew from the Sinkfield Cup and the whole story blew up. Was that a mistake on chess.com's part? Could that come back to bite them?
I don't know. I mean, that's what really the question is going to be. So why? Like, why did they ban him? And if the answer is they banned him because this was blowing up and they looked at it and they went, holy crap, he admitted to cheating, and so we're going to ban him because he admitted to cheating on our website, then no, that makes perfect sense.
But they knew that beforehand. They knew that he had cheated already.
Did they?
Yeah.
Okay.
The admitted cheating was years ago.
Oh, so again, right? Like, it's going to be a question of, what was their internal response and why was it then versus later, right? Is it, hey, this is blowing up, we don't want blowback? Is it, hey, this is blowing up, we could get some attention? Is it, hey, this is blowing up, let's help our friend and our business partner? Like, there are all sorts of potential explanations for what's going on there. And this is one of those things where it's like, as a lawyer on a case like this, I would want to dig into those documents and into those facts and say, okay, let me see what the story is. So yeah, if it was motivated by a desire to help Magnus Carlsen, that could potentially come back to bite them. But there's no way to know that without digging into those documents, which is why we have the discovery process we do.
So one question about discovery. When that process happens, does that mean that all the text messages, that all the emails, all the Discord messages, all of those have to be shown to the judge and or to the other side's lawyers? Is that how it works?
Yes. Good. So you exchange documents, right? So I will, doing a litigation, I will ask the other side, I want all of your relevant communications on topic A. I want all of your relevant documents on topic B, and I'll give them instructions. You need to get me in a way that preserves the metadata so I can see who sent what to who. I can ensure that it's not forged. I can sort and filter by date and time sent and all of that information. And I need you to collect your messaging apps and your Discords and your text messages and everything else, not just your emails, not just your Word documents, everything. Mm-hmm. Discovery can be an enormously expensive process depending on how much data that you're talking about. And, this is one of those cases where it's going to be probably not as expensive, if only because it's such a limited time frame where there's going to be relevant documents. But a lot of times what you have is individuals end up with a large advantage over big companies because an individual will have, 500 relevant documents, 5,000 relevant documents, and a large company will have a terabyte of relevant documents. And it can get enormously expensive because then you have to gather it and then you have to filter it and review it. And before I produce documents, I'm going to make sure that I'm only turning over relevant documents. I'm not giving you stuff you don't need. And also, I need to know what's in them so I can know what you're going to do with them to help my case or to hurt my case. So it can be an enormously expensive process.
It also sounds like a rather painful process for the individuals because Hans will have to give over all his Discord messages with private parties, with possibly Danny, because he was involved with chess.com as well. Hikaru will have to do the same, I assume. So all these individuals will have to do this.
Well, again, I think Hikaru Nakamura is going to get dismissed out very early. So, what he's going to have, and really the only thing that he did that's relevant is these streams where he discussed the incident. So, any document request, any subpoena to him is really going to be limited to give me all of your communications about this incident. Anybody you spoke to about it, any discussion you had about it, any analysis you did of it, any underlying documents related to it. It's not like you can just be like, hey, give me all of your communications with Magnus Carlsen, because it's not relevant. Mm-hmm. So.
Cool. Well, any other questions, Fabi?
I think we covered a lot of ground there.
I think so too. Awesome. Akiva, thank you very much for joining us. Thank you very much for
thank you, Akiva.
Answering all the questions.
Fun, so thank you.
We appreciate that, and as this thing drags on, maybe we will reconnect.
Yeah, absolutely. This was fun.
Awesome.
Thanks, guys.
Thank you very much.
Thank you.
Appreciate it.
So long.
Bye. Cool. Fabi, all right, we're back.
That was interesting.
That was very interesting, and just to address a couple of technical problems, we apologize for all the interruptions at the beginning of it. But yes, I think towards the end, actually, it was quite smooth. So that was good.
Yeah, it looked like his internet went through some, but it came back at some point.
It did.
So we had a lot of smooth dialogue as well, which was good.
It did. What's your initial impression of what our lawyer just confessed or said?
Yeah, I mean, he seemed to be very positive for the defendant sides.
Especially
I
for
suspect
everybody except Magnus. Yeah.
it seemed already before we spoke that it was very likely that Hikaru, there's not much against him, and probably he won't have any serious legal problems. And yeah, it looks like the main arguments are going to be against Magnus and against chess.com.
But from my understanding, chess.com can file for a motion of dismissal based on jurisdiction early on.
Maybe, yeah, the jurisdiction question, I don't know, but I was like, where could you file that? I mean, Akiva mentioned Connecticut,
yes,
because that's where Hans is from.
But those were the slap laws, right? The slap laws were a problem.
Yeah, that's what he said. But also, would Connecticut have any jurisdiction over these parties? I mean, none of them are from Connecticut. None of them played a tournament in Connecticut. At least Magnus played a tournament in Missouri. So if we're talking jurisdiction, leaving outside all the other parties, because we already said like Hikaru is probably going to get dismissed for more than one reason. So at least Magnus was here during the incident in question. Actually, I was kind of wondering about discovery, because you remember that we heard that Danny and Hans had all these Discord messages, right?
I think it was Slack messages, yes.
Oh, was it Slack? Oh, yeah, sorry. Slack messages.
Yeah, I think this is something that Hans mentioned during his interview with Alejandro. He was mentioning that all of his Slack messages were deleted, if I'm not mistaken.
Yeah. Yeah, we heard that Slack messages were deleted. I don't know. Does that mean that they won't go to discovery? I also don't know how this works, right? If messages were deleted, can you retrieve them? But yeah, I mean, the whole process to me sounds very, very painful for the people involved. Like, to me, it's not going to seem fun that, let's say you and I were talking about chess, and suddenly I have to give all my messages over to lawyers with you, and they'll be picked apart. Like,
That's terrible. That's
yeah.
That's horrendous. Yeah, what do you think the impact is going to be on the involved parties? I'm not necessarily worried too much about chess.com's mental state or Hikaru's mental state, as we've seen probably Hikaru is most likely going to get dismissed, or at least that's what the lawyers seem to think. But what do you think is going to happen with Magnus and Hans in terms of their chess abilities?
Oh, I don't know if it'll affect their chess. I mean, Magnus will get his lawyers. They'll do all of the work. I think, as Akiva said, Magnus's first priority should be that it doesn't go to a trial. That
that it gets dismissed.
It goes to a judge, gets dismissed, and goes on with his life. Yeah, and the lawyer costs, I don't think Magnus will go bankrupt over. But for Hans, of course, it's maybe a bit more of a personal thing, because it's his initiative. He's emotionally invested in it too, right?
Yeah.
He really wants a successful case, even if he doesn't get money, as Akiva said. If it's just dismissed based on not being able to prove Magnus's state of mind, but still that Magnus made incorrect claims, even if it says that, then it is a moral victory for Hans, right?
I don't
then it's
think
like
he's looking for moral victories, to be honest.
that he just wants to see the money.
I think he's interested in trying to get some cash, because I feel he believes that his career has been gravely affected, and obviously through his career his potential of earning. So I think he wants that, maybe not even necessarily for the money, but for the moral compensation of having to go through all of these things and having lost so well, in his mind at least, so much money, because, and he mentioned this in the lawsuit, his invitation got rescinded from Vaikanze, and I believe there was also a match that he was supposed to play with Kamer in Germany that got rescinded as well. So he already feels like he got financially affected based on what transpired.
Yeah, we heard this from him, right? He said like he had this match scheduled with Vincent Keimer, and then Keimer suddenly just stopped responding. Again, we don't know the facts of this, just this is what Hans said. Which, yeah, I mean, you can prove that there was some sort of negative impact financially for him based on what happened.
I think that I think he can definitely prove that.
I think that's clear, but it seems like the question of whether or not Magnus is legally at fault is, did he say something he knew to be false? Whether or not he said something which caused Hans to lose an invitation to Vaikanze or to this match, yeah, this already, you can draw a clear parallel between that, right?
Mm-hmm.
That these accusations were made, or insinuations were made, and then Hans lost this invitation, right? But it seems like Magnus, still has to be shown that Magnus or Chess.com, that or Play Magnus Group or Danny Wrench, or all the parties involved, that they had to have said something which they knew to be false.
Right?
I think
this is very difficult to prove. This is going to be very difficult to prove.
It's a state of mind thing. I mean, if you say something and I know that what you're saying is false, right? Let's just say you say the earth is flat. I still don't know if this is a genuinely held opinion by you, which just happens to be false, right? So I guess it's very hard to prove that. I'm sure there's ways, like let's say Magnus sent a text after he left the game to someone, to one of his good friends, saying, "Oh yeah, I knew that I knew he's not cheating, but the kid beat me, and I wanted to hurt him, ruin his career."
Yeah,
right. I mean, short of that happening, and I very much doubt that anything like that happened. It's difficult to prove this stuff, but I guess all this will be
revealed, in court, if it goes to discovery.
No, it will, right? It's not going to be. I don't think it's going to be dismissed. I mean, for Magnus, I don't think it's going to be dismissed with just a glance at the lawsuit.
You don't think he has grounds for dismissal?
Well, I mean, what Akiva said was that this isn't a frivolous lawsuit.
Yeah.
If there is merit to parts of it, obviously not all of it. I mean, it is, the language and everything is juiced up a lot, right?
Yeah.
You can just by reading it, you can see that a lot of it is hype as well, right? I mean, like having quotation marks, Magnus the
king of chess,
notorious for his inability to cope with defeat, Carlsen snapped. Enraged that the young Niemann, fully 12 years his junior, dared to disrespect the quote-unquote king of chess, and fearful that the young prodigy would further blemish his multi-million-dollar brand, etc., etc. I mean, this is like very hyped up language. But as Akiva said, it is also probably to generate some buzz and some publicity and to change the narrative a bit, right, in the media.
Yeah.
But yeah, the language is very funny. Like reading through it, Carlsen, the king of chess, gutlessly forfeited the game after making one move. I mean, it's pretty funny.
It is.
I don't know, like, how would a judge? Akiva said a judge wouldn't. It wouldn't damage the case just based on the language, but it does seem like generating buzz isn't the most honest way of going about it, but if he says it won't damage the case, then that's probably true.
Yeah. All right. Well, this one is definitely going to go on for a while, and I'm sure we'll have the opportunity to discuss it more as it progresses. I think for today we're more or less done. We covered a lot of ground. We exposed a lot of views and tried to stay as unbiased as possible. And I think the lawyer also was as unbiased as possible, because there's absolutely nothing that Akiva could gain out of this. They're not involved in any way.
Yeah.
So
No, I mean, I saw some people in chat were saying that Akiva is biased, but the guy isn't a chess player. He doesn't care who Magnus is, who Hans is. I mean, he doesn't have any skin in the game. So I don't see why his opinion wouldn't be fully unbiased
yeah,
and based purely on the law as he understands it.
yeah. Cool. All right. Well, I think we might call it a day on this one. Thank you very much for tuning in, guys. Appreciate you. Hope we provided an important piece of the puzzle towards the public conversation. At least this is what we are intending to do with this podcast. So we appreciate you joining in. If you liked it, don't forget, like it, subscribe it, share it, things of that nature. And I think we will be back tomorrow. Actually, we do have a podcast dropping tomorrow.
Yeah, and the funny thing is that we do talk a little bit about the lawsuit in the one tomorrow, but that was filmed last week. So
correct. That is the post champs podcast.
But it was nothing changed since then. There was no news about the lawsuit whatsoever.
Yeah,
which makes sense, because why these things go slowly, so we could have expected it. But anyway, we will talk a little bit about that again tomorrow, which now we have, of course, a much broader perspective on everything.
Oh, absolutely. And yeah, tomorrow, stay tuned. Don't forget, episode 8 of our weekly podcast that drops every Thursday is going to drop tomorrow. And yeah, you will get to hear all about Fabiano's US Championship win, his thoughts and things of that nature, and everything else in between. So we will be back tomorrow. Anyway, Fabi, nice chatting with you.
Yeah, and, good talking to you too. Thank you guys for watching.
I think we will be back soon. Talk to you soon, guys. Bye.